the U.S. now is using its hard powers simply not to promote global interests like reducing oil pollution or protecting whales, but simply to promote U.S. interests in getting access to minerals in Greenland or control over the Panama Canal. I think that is going to lead to a backlash. I think it's going to make countries much more reluctant to cooperate with the U.S. and other issues.
In this ClimateGenn episode, I'm speaking with the Regents Professor at Arizona State University's Sandra Day O'Connor College of Law, Dan Bodansky, about the second edition of his book, The Art and Craft of International Law. Dan is a recognized expert, having worked on a range of negotiations across the decades, including being part of the US negotiating team at the UNFCCC in the 1990s. Dan talks through how international environmental law has evolved with state and non-state actors, including how civil society plays a role in creating momentum that can translate into societal norms that lead to international agreements. All of this is set against the rogue nature of the current US administration and the drastically reduced operating space in which we have to preserve a livable climate. In the next episode, I'm speaking with Professor Jennifer Francis from the Woods Hole Research Center for an update on recent sea ice loss in the Arctic and the myriad impacts this has on so many other parts of the global climate system. Forthcoming episodes also include my speaking with Zita Sebasvari, Deputy Director of the United Nations University Institute for Environmental and Human Security, who is the lead author on a new interconnected disaster risks report. And also an in-depth discussion with Professor Mike McCracken from the US about the role of solar radiation management geoengineering, offering a nuanced response to my recent interview with Professor Raymond Pierre Humbert. Thank you to all subscribers. Please do send feedback or like and share episodes, or become a member on YouTube or Patreon to support the channel. Thank you. Dan, it's great to see you again. Thank you very much for taking the time. I'm looking forward to speaking to you about your book, The Art and Craft of International Environmental Law, which is actually very, very illuminating to someone who wishes they read it before they started going to COPs. But in the book, you recall saying in the 90s, when you were working with the US climate negotiating team, that tens of thousands in attendance, but only 100 people actually do anything. And you quickly acknowledge this isn't really the case. But if we use the UN Framework Convention on Climate Change, the UNFCCC, as an example, amid the entanglement of many state and non-state actors, who are the groups that really matter within the entirety of the COP itself? And can you talk about the dynamics of these groups through the lens of international environmental law?
Well, thanks. It's a pleasure to be here. When I told that story, it was really to indicate the somewhat blinkered view that government representatives take when they go to meetings like the COP. They tend to focus on the official part of the agenda, what kind of decisions are going to be made, and relatively few people are directly involved in that. But the COPs have now taken on a much, much broader significance. So when I thought as a negotiator that everybody else was just there doing who knows what, that reflected a fairly narrow, limited view. So there are now all sorts of activities going on at the COP and elsewhere. And one of the things that's changed between the first edition of my book, which came out in 2009, and the second edition, which came out last year by Oxford University Press, is that we focus much more on the role of non-state actors. So the first edition discussed non-state actors some, but really was largely state-centric. And I think one of the things that already had emerged back in 2009, but has become much, much more prominent, is the role of non-state actors. So non-state actors engage in the climate process and international environmental law in all sorts of ways. First of all, they do try to influence states, either to take stronger action, in the case of environmental NGOs, or in some cases, greener businesses. also try to lobby for a weaker regulation, in some cases by businesses. But then they're also developing new technologies, they're developing new ideas. There's lots of think tanks that engage in the climate process. The climate meetings are now, in addition to being intergovernmental meetings, they're like a sort of mini academic or policy conferences with all sorts of different groups presenting their latest ideas. And so, a lot of these ideas then work their way into the process. It's also an opportunity for NGOs to mobilize and try to rally public support for stronger action on climate change. And then now there's actually significant attempts to influence the climate change process using the courts. And so that's another thing that I think has changed significantly between the first edition and the second edition. Back in 2009, I think courts were playing a relatively small role in international environmental law. International environmental law was largely oriented towards negotiations and negotiated outcomes among states in the form of treaties and other kinds of documents. But now courts are beginning to play a much bigger role, and that includes both the courts within countries, national courts, but also now attempts to try to get the international court system involved. So there's been requests this year for advisory opinions from the International Tribunal for the Law of the Sea, which issued an advisory opinion last year, from the International Court of Justice, from the Inter-American Court of Human Rights, as well as literally hundreds or thousands of cases that have been brought within national court systems. So again, most of that activity is by non-state actors, is by litigation-oriented NGOs. So that's another way now, another lever that non-state actors are trying to use to try to bring about stronger action on issues like climate change.
In the sort of creation of these treaties and other various agreements that come out of these processes, there's one term that seems to come up, and it's the idea of establishing norms. And from that, the agreements come about, or they start to gather momentum and sort of validity. Can you talk about the importance of this establishment of norms? Because I keep hearing it. I've heard it, it was in the book, but I also heard it on panels as well.
International environmental law, like international law generally, lacks very strong enforcement mechanisms. So it doesn't operate in most cases the way domestic law might operate, where you can get a decision and then get some kind of enforcement of that decision by the government. So the way international environmental law can try to influence behavior, it can provide new knowledge. So countries have different views about their interests, but it can also establish sort of new norms as to what appropriate behavior is. And those norms, in some cases, at least hopefully get internalized by government officials, or even if they're not internalized, they're taken up by non-state actors who then put pressure on governments to change their behavior. So either directly through governments or through sort of the wider community, civil society, norms can penetrate, and then ultimately norms can influence behavior, because what norms are basically rules about what the appropriate behavior is or what inappropriate behavior is. So even if there might be no enforcement of the norms, at least in many cases, the norms do influence people either internally through their sense of what's right or wrong, or externally because others care about them and you don't want to suffer reputational losses or other kinds of sanctions for violating what are widely seen as norms. So just take one example. Back when I was growing up, wetlands were usually referred to as swamps and things that you wanted to get rid of. We drained around the Panama Canal to build the Panama Canal back in the early 20th century. They were seen as disease-ridden areas. Now swamps are generally referred to as wetlands, and we understand their ecosystem services, all the benefits they provide, which then is part of the basis for the Ramsar Convention to protect wetlands, where countries designate wetlands for protection. So the attitudes towards wetlands and the development of a much greater understanding of the role that they play and the value they provide, it's due to all sorts of different factors, of course, developments in science and so forth. But I think it can also, to some degree at least, be due to the development of norms such as the ones in the Ramsar Convention on wetlands, which then propagate these new views about wetlands, about their value more broadly throughout the international community. But of course, as we can see in the US right now, norms, guardrails have their limits. So if people are committed to violating the norms or have no respect for the norms don't necessarily prevent conduct, but I think they provide some guidance. So at least at the margin, they can influence behavior, but they don't always, as we can see, always determine people's behavior.
Well, we'll come back to the US in a second, but I was just thinking in terms, you were talking about the international environmental law doesn't have much scope for enforcement, and the norms play this role of almost like you're right from you're wrong. And in 2015 in Paris, there was this sort of huge thrust of momentum that everyone was going to sign this. It seemed like the whole world was pretty much on board with it. But as states commitments to the agreement have floundered, it does feel like there's a failure in the non-binding nature of this. That the fact that the agreement doesn't have any teeth is the route to failure. Do you think that's fair, or do you think that it's the best we can do with the processes we have?
I think it's done less than I would have hoped, that I think most people would have hoped. I guess the question is what the alternative is. The Kyoto Protocol had binding emission reduction targets. That was the agreement adopted back in 1997, which set quantitative targets for countries to reduce their greenhouse gas emissions. It applied only to the developed world. The US never joined it, but it had legally binding targets, legally binding obligations, and those targets were quantitatively specified. So it was quite easy to see whether countries were complying with the target reductions or not. So you might say, well, Kyoto is a better approach because it's more stringent, it can be more ambitious. The problem, of course, was that countries largely didn't participate in Kyoto. Kyoto only covered about a quarter of global emissions in the first commitment period. And then when it was extended into the second commitment period, I think it only covered about 15% of global emissions. So the effectiveness of a treaty, how much it does to address environmental problems, is a function not just of how strong it is, but also how many countries, which countries participate. So you can have a very strong treaty. If countries don't participate in the treaty, it's not going to do much. Conversely, of course, if you have a treaty where you try to get participation by weakening the treaty, you get a lot of participation, but the treaty may not be that effective because it's fairly weak. So the problem is to try to sort of optimize how much the treaty is able to do. How far can you go in making it more stringent without losing the participation of key countries? I think after the failure of the Kyoto Protocol to really get buy-in from most of the big emitters, other than the European Union, countries decided, well, that approach isn't going to work. We need to try to get an approach that will get more buy-in. And the Paris Agreement has been extremely successful until Trump recently pulled the US out, but it had been extremely successful in getting essentially universal participation. And so the way it was able to get universal participation was to allow countries to set their own nationally determined contribution, to not make those contributions legally binding. So in those respects, it was weak. It tried to compensate for that by having legal requirements about transparency. And the theory was if countries have to come out with a statement about what they're going to do, and then there's transparency, they have to report on what they are doing so you can really see whether they're living up to what they committed to do. That would be an inducement to countries to try to put their best foot forward and their contribution that they pledged, and then to try to meet that contribution. That was the theory. I think at the time that was about the best countries could have done because there was no appetite to have another Kyoto kind of treaty. I think it was justifiable to say, well, we need to find some kind of architecture for the treaty that countries can really buy into, that gets widespread support. Try something new, essentially. Now, they did try something new, the Paris Agreement. I think it's done something. From what I understand, the projections about global warming temperature increase have declined from what they were as of the time Paris was adopted. So I think arguably Paris has had an effect in trying to get countries to come forward with stronger domestic climate action, but it hasn't done nearly enough. So in my view, better than nothing, probably better than continuing down the Kyoto path, but certainly not as much as we need.
If you look at, that it is actually the US who's upending the Paris stuff, even, from the first Trump administration, it shows the importance of non-state actors, NGOs, the civil society narrative in the domestic scene that feeds back into the whole process, is that perhaps we sort of undervalue that sometimes. Going back to this idea of the norms and the United States, the current administration is creating fear, is creating uncertainty, given their centrality to the whole processes, pretty much all these processes in the post-war era. Is this a fatal blow, do you feel, to the progress that international environmental law has made over the last half century or that kind of timescale?
I'd hate to say it's a fatal blow. I think it's a tremendous setback. Whether it proves to be a fatal blow or not, I think remains to be seen, but it's certainly a huge, huge setback. Not just because of the effect it has on the climate regime, but it also has an effect on whether countries are going to view the U.S. as a partner they can negotiate with going forward on other issues like plastics, for example. So if the U.S., it is seen now as unreliable, every 4 years it can change its position 180 degrees. These treaties are dealing with long-term problems, and you need some consistency over time to try to address them, so that if it's just veering back and forth between one view and another view every 4 years, it doesn't build in the kind of long-term outlook that you need to try to influence business to, change what their investment patterns are, change consumer behavior. So I think it's extremely problematic. And just in general, I mean, even apart from just the effects in particular on the climate change regime, it's going to have definitely a negative impact on the climate regime. I think in the obvious way that the US is pulling out, and so that gives other countries more of an excuse to not do as much. It also means that world's second biggest emitter isn't going to be working to try to reduce its emissions, try to meet the contribution, the pledge that the Biden administration made. So that, of course, has a direct effect. The U.S., I think also, though, over the years has played a fairly constructive role, at least during some administrations, in trying to broker compromises. So the Paris Agreement, for example, which was able to get on board, not just the countries that were really eager to take climate action, like European countries or small island states, African group, but also big emitters like China, India, Brazil. Without the US, whether we would have had anything coming out of the Paris process, I think is unclear. I think the US does play a constructive role in trying to get to agreement. Some people, of course, think the agreement's too weak, so they don't think that role was that great. But I think without that, we would have had nothing. And so I guess my view is something is better than nothing. So Paris, for all its weaknesses, is better than not having come to an agreement at all. And so I think the same thing was true of the Paris rulebook negotiations, the detailed rules for how Paris operates, which again, I think the US did play, even during the Trump administration, surprisingly played a constructive role in trying to broker compromises. And I think in a lot of treaties, the US has played a key role in trying to find some compromise solutions. So without the US, if they're sitting on the sideline, it's a little unclear who will play that kind of leadership role. The EU, I think, would like to, but the EU tends to be more on one end of the spectrum on environmental issues, and whether they can broker deals with countries like Saudi Arabia, China, India, countries that are really essential for a treaty to work. So you need to try to somehow figure out how you can get them in, whether without the US, anybody else is going to be able to try to get those compromised, I think is unclear.
Okay. And you've been involved with the US negotiating team, and you've seen how things have unfolded throughout pretty much most of the process, I imagine. Can you talk a little bit, you mentioned this in the book, it's about the role of what we're seeing now, for example, there's this sort of idea of hard power coming into the scene. Europe might like to take a bigger role, but although they are a kind of superpower as a collective, it's also a disparate power. How do you think that axis can shift going forward with sort of negative forces at play?
So first of all, hard power has played a relatively small role in international environmental law, although I think it's played some role. For example, the threat of unilateral action by Britain back in the 1960s, by the US in the 1970s, is one of the things that helped propel getting an agreement on oil pollution from tankers. So that was a case where countries sort of used, I don't know, hard power, but certainly not just soft power, because they were threatening to take unilateral action had an effect. Or similarly, the U.S. threats to impose sanctions against countries that continue to whale, I think, was one of the factors that has gotten countries to stop whaling. So that's examples where it's not just relying on norms or more general kinds of softer forces where countries really use their power to try to get other countries to go along with stricter environmental regulation. So the U.S. now is using its hard powers simply not to promote global interests like reducing oil pollution or protecting whales, but simply to promote U.S. interests in getting access to minerals in Greenland or control over the Panama Canal. I think that is going to lead to a backlash. I think it's going to make, obviously, countries much more reluctant to cooperate with the U.S. and other issues. So I see that as definitely limiting. It's better to try to get your way through cajoling and through working with other countries than it is to simply bully them all the time. And so I think the bullying approach, might have some short-term gains, but I think it'll have a lot of longer-term costs.
Just to pivot a little bit away from that, as we proceed now, we know that we're heading to catastrophic levels of atmospheric carbon concentrations. I mean, we're on target for something like a plus 2.7 degrees warming above the pre-industrial. Geoengineering is getting funding and it's become a serious topic of debate at side events at the COP. Given all that we've discussed previously, can you describe a pathway that might lead through the COP process, or perhaps with or through other multilateral organizations, towards a sort of deployment of solar radiation management? And you do actually mention this technique briefly in the book.
Well, I think at this point, we don't really know enough about solar radiation management, or SRM as it's called, to know whether it can be deployed effectively, safely. So I think it's premature to be thinking about deployment of SRM. I think what's urgently needed is more research on SRM because, first of all, SRM could potentially help address climate change problems. It's not certainly the only solution. We need to be reducing emissions, but it could help as we're reducing our pollution of sulfur dioxide. Sulfur dioxide screens sunlight from the earth and actually cools the planet off. So as we're dealing with pollution from sulfur dioxide, we're actually exacerbating climate change. So putting some sulfur dioxide into the upper atmosphere to try to compensate for the reductions in sulfur dioxide in the lower atmosphere, to my mind, is something we should definitely be looking into. So if we don't do research, we won't know whether SRM can be done safely and effectively. So we should be doing it for that reason. But I think there's also a huge danger that if we don't do research, countries will still, in desperation, may use it down the road, and then they'll be using it without knowing how to use it most safely and effectively. So I don't think not doing research will prevent SRM deployment eventually if countries get desperate enough. So in my mind, we should be doing a lot more research. And right now, I think the problem is SRM still has a huge stigma attached to it, and scientists are quite reluctant to do research. It's hard to do research. Research, when it's proposed, often gets shut down. I think 26 states in the U.S. now are passing legislation to try to prohibit any injection of anything into the atmosphere. Really not based on SRM concerns about that, but based on the conspiracy theory about chemtrails. So SRM is the collateral damage from the chemtrails conspiracy theory, which will make it more difficult to do atmospheric research on solar radiation management. So I think what's needed is governments to begin funding research programs, as the UK has done. UK is one of the first, and really try to understand SRM better so we really understand whether it could play a role in addressing climate change.
I've heard two experts in the geoengineering field say recently that we should start deploying now that we know more than we think, and with very accelerated mitigation and advances on CDR, it could provide one route to the future. Now, that's highly controversial, I know, but if we were going to even go to what you were saying about more research and being inclusive, the COP system, for all its faults, actually has nearly everybody or everybody at the table so that you could have an inclusive discussion with the global south having a voice. Do you think that that is a forum that could be a starting point for this kind of discussion? At the moment, we're talking about side events that I referenced earlier, but actually making it more
Yeah.
advanced.
The UNFCCC process hasn't been really known for being super functional process, so I have, I guess, some concern about whether putting it into the UNFCCC process would really be helpful or not. But I do think more inclusive research. There's a lot of fear about SRM, so trying to broaden the basis to who's involved, talk to a much wider group of countries. And yes, I think eventually, perhaps the UNFCCC could be a place to at least have discussions, try to reassure countries. I think the research should be coordinated internationally through something like the World Climate Research Program. It should be coordinated scientifically in terms of not figuring out what questions most urgently need to be answered, try to divvy those up, try to do assessments as to what we actually know about geoengineering. So you say several scientists think we know enough now to deploy. So I guess I would be very interested in having a more general assessment by scientists along like IPCC kinds of process to see what the consensus is. The problem now is a lot of the discussions of SRM are really not scientifically based. They're based in morality, ethical concerns, religious concerns about tampering with God's creation. So I think we really need to try to, as much as possible, I know it's difficult, but to focus on the science of SRM. And so having more inclusive science involving scientists from other parts of the world, but also have assessment processes. And then I think it is important to be trying to reach out to governments, try to understand where they're coming from, what their concerns are. So yeah, I think all of the above really. But I think what we really need is, we're spending maybe tens of millions of dollars. We need to be spending, if climate change is really an emergency or crisis, and SRM is one of the few ways we might be able to address it quickly, uh, without disrupting the global economy, then I think we should be not spending tens of millions. We should be having more like a Manhattan Project to try to understand, or something like a moonshot to try to really understand it, develop the technologies, see whether we think it can be done safe. Something like warp speed on the vaccine, which really developed the vaccine extremely quickly. The development of the vaccine didn't mean it was going to be used. It then had to be tested for safety and so forth. If it had been shown to be unsafe, then it wouldn't have been rolled out the way it was. But trying to have really an all hands on deck attempt to try to understand it, SRM, what the potential issues are, how it can be done most effectively and safely. I think that's really a priority, but there's very little constituency right now for that. So it does seem like an unlikely prospect, but I think that's what we really need right now.
I remember Martin Rees in Cambridge saying quite a while ago that he thought the only people who would do well out of solar radiation geoengineering would be the lawyers. So I imagine that if it does go ahead, the third edition of your book is going to have quite a substantial addition to
Yes, although
it.
I should say, so first of all, I was very happy when you said at the outset that you wish you'd read the book earlier, because the book is intended for a very broad audience, for people who don't have background in international environmental law. It's written in a way, hopefully, that is understandable to people. But this point in relation to geoengineering is the book doesn't really focus so much on the substantive problems like climate change or geoengineering. It really tries to understand how international environmental law works, or doesn't work in some cases. So what is the process by which norms get adopted, promulgated, implemented, and maybe in some cases enforced? So it's trying to understand that process so people can have a better understanding as to what international environmental law can do, but also what the limits of international environmental law. I call it a 30% solution, and that's just an arbitrary number I came up with, but to indicate that it's less, it's not the most important thing in dealing with a problem like climate change or any other environmental problem. A lot's going to depend on politics, on science, on economics, on social attitudes. So international environmental law can play a role, but it's not the key role. So the idea of the book is to try to give some idea for people who aren't involved in the process as to how it works. And so that can then help better understanding what international environmental law might be able to do on geoengineering, but unlikely that I would be focusing in particular on geoengineering because it is much more concerned with how international law works or doesn't work than it is with particular international environmental problems. That's what distinguishes it from a lot of the other books in the field.
It was extremely useful, and it's good to have all that information in one place because when you do go to these conferences, there's so much going on, and you're not quite sure if that's part of this or if it's just a part of a
Right.
circus act or if it's this, what is real, what's not. And the book helps a long way to giving sort of significance and trying to understand what has momentum, what doesn't, and so on. So
Well,
yeah,
thank you.
so thank you very much, Dan. It's been great to speak to you.
Very nice speaking with you. Thanks.
If you are concerned about the future, then why not travel with me through every COP conference from COP21 in Paris to COP28 in Dubai by ordering my book COP Out: How Governments Have Failed the People on Climate. In COP Out you'll gain insights into what is actually going on in these supposed world-saving conferences and how we have ended up in this dire era of dangerous consequences. You can order COP Out via the link in the notes or on any online bookstore worldwide in paperback or audio version.